Hello, my name is Jeff Capel and I'm the hearing examiner for the City of Tacoma. I'm here to explain a bit about what the hearing examiner is and does, and about the hearing examiner process in the City of Tacoma. I should probably start by saying that the hearing examiner has nothing to do with ears or testing them. In this context, hearing means a process similar in many respects to a court trial, where parties interested in a city administrative decision get the opportunity to be heard or present their case in a formal hearing and obtain a final written decision, or in a small handful of matters, a written recommendation that then goes to the City Council for a legislative decision. In this process, the hearing examiner functions essentially like a judge. The parties present their cases, including physical evidence and sworn testimony, and the hearing examiner, after hearing it all, deliberates and issues a written decision or recommendation to the City Council. Whether a decision issues or whether the end result of any given hearing is simply a recommendation is determined by the Tacoma Municipal Code, or the TMC for short, and which ones are which can be found in TMC Title I at Chapter 23. Which is the chapter in the TMC about the Office of the Hearing Examiner, and that's a very good place to become familiar with if you're involved in a hearing. TMC 123 specifies essentially two different categories of hearing. Some city business that requires a hearing, such as rezones of real property and street vacations, have to be decided legislatively by the City Council. In most of those matters, the hearing examiner conducts a hearing for the council and then makes a formal recommendation to the council, with the City Council making the final decision, usually by ordinance. These items are found in TMC 123.050A. Most other items the hearing examiner has jurisdiction over are found in TMC 123.050B. For the 050B matters, the hearing examiner acts as the city's administrative law judge, and his decision is the city's final decision on that matter. On occasion, I've been asked, don't you work for the city? And the answer is yes. The hearing examiner is technically a city employee, just like judges are technically employed by the city, county, and the state. That said, the TMC requires the hearing examiner to be fair and impartial in all decisions. In addition, the hearing examiner is required to be independent of city departments, boards, and commissions. And so even though employed by the city, the terms of the hearing examiner's appointment require separation from the city and fair and unbiased decision-making for all parties in a hearing examiner proceeding. Above all, the hearing examiner is required to follow the law, which includes the TMC, state and federal laws, and both the state and federal constitutions, as well as controlling case law. Sometimes it might seem like the law itself is unfair, and that's part of the challenge of being the hearing examiner. Following the law is required while still providing a fair and impartial process to all parties and a fair and impartial decision that conforms to controlling laws and ordinances. So most hearings are conducted here in the City Council chambers. I sit up here at the dais, together with my hearing clerk, who oversees logistics, including making a digital audio recording of the hearing as part of the official record. The parties sit at these two tables. Witnesses can testify from the podium, from the witness box over here, or even from the parties table if they so choose. Because hearings are more or less formal, testimony is taken under oath and penalty of perjury. Thanks to the COVID-19 pandemic, starting in late March of 2020, we started conducting hearings over the internet using the ubiquitous Zoom format. Internet hearings have actually presented a number of advantages over the traditional in-person hearing. You and your witnesses get to stay in the comfort of your own homes without having to travel and pay for parking in downtown Tacoma. We get a video recording of the hearing and not just audio, and internet hearings make it easier through screen sharing to be focused on exhibits at the same time during a hearing. Because of some of these advantages, we will most likely continue to conduct remote internet hearings even after in-person meeting restrictions due to the pandemic are lifted. In a hearing, typically the appellant will go first in presenting their case. Order of presentation usually follows the party who has what's called the burden of proof. In a formal proceeding like a trial or a hearing examiner hearing, the law assigns a burden of proof to one of the parties. In most hearing examiner proceedings, the appellant bears the burden of proof by what's called a preponderance of the evidence, which means the appellant must show through evidence and testimony that his or her position is the correct one. During the hearing, the party with the burden of proof usually gets to present first as well as last, after the respondent. Hearings usually follow this progression. An introductory outline of the procedure will be given by the hearing examiner, addressing any preliminary matters, then an opportunity for opening statements from both sides, then the presentation of the appellant's case, including any witnesses. There will be the opportunity for cross-examination of the appellant's witnesses, then the presentation of the city or the respondent's case, including any witnesses. Then the opportunity for the appellant to cross-examine the city staff and witnesses, or the respondent if it's not the city. Then presentation by any other respondents, interveners, and their witnesses. Finally, the opportunity for cross-examination of the respondent's witnesses, followed by questioning by the examiner if there are any, and sometimes I ask questions while we're in the way as well, followed by rebuttal evidence, and then closing arguments or closing statements by each party. Here are some other things that you should know about the hearing examiner process. Once an appeal has begun, all communications with the hearing examiner have to include all parties to the appeal in order to preserve fairness and not become a prohibited ex parte communication or contact. The hearing examiner and staff can give guidance on procedural matters, but cannot give substantive legal advice or tell you how to substantively present your appeal. Although many parties choose to be represented by an attorney in the hearing examiner process, it is not required. The decision to hire an attorney is yours to make, and there is not a different standard for those represented by legal counsel and those who represent themselves. Many appeals have a fee that must be paid at the time the appeal is filed. The city's fee schedule can be found here. The hearing examiner is not a mediator, meaning he does not engage with the parties in a back and forth discussion outside of the hearing in an attempt to resolve the disputed subject matter of the appeal. He does not have that authority under controlling law, but to the extent that the parties to an appeal want to explore resolution of their dispute while an appeal is pending, the hearing examiner usually encourages that kind of collaboration and communication. In some appeals, the parties either request, or the hearing examiner requires, a pre-hearing conference in order to address procedural matters such as scheduling, motions, and discovery, which is the exchange of information. Pre-hearing conferences can be held in person at the hearing examiner's office, over the internet by Zoom, or even telephonically. That probably seems like a lot to digest. Most of the information in this video and more can be found on the hearing examiner's pages on the City of Tacoma's website, right here, including answers to frequently asked questions and links to the hearing examiner's rules of procedure, which are good to know if you're going to be involved in a hearing. Being informed is the best way to be. Hopefully, this video has helped get you a little bit better informed about the hearing examiner process. Thank you for watching.